Lordships had fixed item 22, the DGP matter at 2 p.m. Your Lordships, there was some urgency in Tamil Nadu because elections are there. Your Lordships had fixed 22, the DGP matter. In that, the Tamil Nadu DGP application, Your Lordships, has some urgency because in May the elections are coming and UPSC has sent the recommendation as directed by Your
We'll
Lordships.
take up that matter just now.
Very well.
Yes, yes, Mr. Jain, what is the position in this matter?
Lordship, on the last occasion, you had very kindly ordered that all the AORs should file supplementary information. So far, I've received about 150, total about 550 AORs information I've received. Another 600 odd are pending. We are pursuing with them, sir. Second, your Lordships had ordered that some interveners had petitioned this honorable court that they are not part of the subvention scheme. You had asked to examine. I'm in the process of.
To be detect, kind of.
Yes, sir. I'm in the process of doing that. I'll solicit some more time from you, sir.
So that will take some time for you also to examine.
Yes, sir. So I prepared a brief report, but there's nothing substantive but for what I've mentioned.
And what about the investigating agency, Madam Ashwin?
My lords, we have received 44 petitions, my lords. We also have a status note, but there is nothing substantial in the last status report that your lordships had already seen, my lord. After that, we are scrutinizing the my lords, the documents that we have received. Once we scrutinize it, then we will put it in different categories for your lordships to see.
Any information regarding this Rouse Avenue court where the charge sheets were filed?
Yes, my lord. So this status report has that update, my lords. The 3 RCs.
Or you are filing a status report?
Yes, my lords. I'm carrying a status report. So, my lords, there were 3 cases that we had completed our investigation. Cognizance has been taken in all 3, my lords. The date your lordships will find. This is 3 regular RCs. Cognizance taken is the last column, my lords. 27 January, 3rd of February and 3rd of February. 25 RCs are under active investigation. And my lords, we've also, para 3, if your lordships will see, in the 28 regular cases, we have also divided them into 2 portions. 22 cases are projects involving subvention schemes. And therefore, it involves the PC Act, my lords. 6 cases are cases which do not involve subvention scheme. These 28 regular cases, my lords, covers 39 total projects and 17 financial institutions. In last status report, this bifurcation was not given. Only I have given the bifurcation and updated status of cognizance.
The bifurcation mentioned in para 7?
Para 3, your lordships will see.
Oh.
Bifurcation of...
That's right. 22 yes, plus 6.
Please, my lords. And our investigation is continuing in the rest of the 25 cases, my lords. And the 44 cases that we have received from the Learned Amicus's office, we are scrutinizing that, my lords.
Para 10, they are saying that from your office, a list has been received, but not the copies of the petition.
Yes, so my lord,
The council have not supplied to your office.
yes, but my lords, let it not be duplicate. The learned amicus is giving us everything. I think that is fine. 44 we have received from learned amicus. Because 20 of them were anyways common, we tallied, my lords. So we'll just let it be one source from the learned amicus.
All right, right on.
My lord, one submission. One of the charge sheets relates to, my lord, one of the companies which has gone under CIRP. My lord, in view of the CIRP process, my lord, I become the successful resolution applicant. The law now requires, my lord, that that company which is now gone through the CIRP process will be bereft of, my lord, a prosecution under 32A.
There is a question of deleting.
No, the erstwhile promoters will be proceeded against.
We really don't give much credence to this so-called CIRP procedure and all this.
My lords, if I may submit, I'm for one of the impleaders and I pray for the stay of the check bouncing proceedings. He has a similar case and FIR has been registered pursuant to the orders by this honorable court against the builder, AVJ Developers. The CBI has registered an FIR. I'm praying for stay of the proceedings of the check bouncing matter.
All that happened still.
My lords, it was before I became a party. I have filed impleadment and directions.
Same continuation of the previous orders, including dated 22nd July 2025, 28th July 2020, 23rd September 2025, and 20th January 2026. Shri Rajiv Jain, Learned Amicus Curiae, has submitted a brief note number 5, 24th February 2026. It is pointed out that in terms of our previous order dated 20th January 2026, liberty was granted to the petitioners stroke IA applicants in the IA stroke interveners and all other stakeholders to furnish the requisite information to Learned Amicus Curiae with respect to the date of disbursement of loan, installments paid, the status of the project, etc. A format for furnishing such information was also incorporated in the order dated 20th January 26. Next paragraph. In response thereto, information have been received in 216 special petitions pertaining to 1,192 petitioners. However, only 534 of them have furnished information in the prescribed format. Next program. As regard to the liberty granted to the banks stroke financial institutions to submit their claim for deletion of their names or detagging on the premise that they are not they, they have not launched any subvention scheme. Comma. Only two banks stroke HFC have approached the land amicus two financial institutions, namely L&T Finance Limited and PNB Housing Finance Limited, have also sent mails for their deletion.
If I may, sir, learned counsels for some other housing finance companies or banks informed me today that they have submitted emails to me on the same subject. Somehow, perhaps in the barrage of emails that I received, I may have missed that. So Central Bank of India, ICICI, HDFC, they all said that they've also submitted an application to this effect. I've yet to verify, sir.
They also, State Bank of India.
Central Bank of India, HDFC, ICICI.
Have also submitted their claims. All these claims are yet to be verified by the Land Amicus Bureau. Though in the report he has opined that PNB Housing Finance Limited and L&T Housing Finance Limited apparently relate to subvention matters. Next paragraph. Since most of the petitioners, etc., have furnished information very recently, and over 658 petitioners have not come forward. In the interest of justice, we are inclined to grant one more opportunity to those who have yet not furnished the requisite information, to approach the Land Amicus Bureau and submit their respective claims within a period of 1 week. Next paragraph. Land Amicus may examine the claims received so far and may submit a report after collating the information from preferably within 2 weeks thereafter. 1 week after.
Lord, may I submit some? My Lord, on this issue of because some of the builders have approached the amicus and the banks that detag because it is not a subvention scheme in the strict sense that the builder did not launch a subvention scheme, but the scope is builder banker nexus. So if there is a upfront disbursal by the bank to the builder without linking it to stage-wise construction, then it's a clear case of nexus and without verifying whether the builder has clearances.
Nobody deleting them. They are only submitting claims. And the Land Amicus will examine it, then a report will come to us.
Because their objective is once it is detagged, then it goes out of the purview of CBI.
It has been detagged.
Yes, exactly. Because if there is no tripartite agreement,
a status report within 2 weeks thereafter. We also request number 3. Now we also request Bikers Bureau to submit a report to highlight in the report the categorical status with respect to the claims of the parties. Next paragraph. CBI has also filed its third interim status report in a sealed envelope which has been opened in court and the report produced. It is explained that in total 28 regular cases have been registered, out of which 22 cases pertains to builders projects involving home loans and subvention scheme. All these cases have been registered under the Prevention of Corruption Act also against unknown officials of financial institutions. Next point. The remaining 6 cases pertain to builders projects not involving the subvention scheme.
Not involving the subvention scheme.
Three charge sheets filed. It is further explained that out of aforesaid 6 non-PC Act, CBI has completed the investigation in 3 cases and charge sheets have been filed. Investigation in the remaining 25 regular cases is stated to be presently ongoing. It is further explained that at present 25 regular cases are under active investigation and 3 cases wherein charge sheets have been filed have been detagged. The details of these cases are given, is also given in para 7 of the interim report. The affidavit further explains that the list of 45 SLP stock petitions filed meanwhile have been received, but no soft copies of, but out of them, soft copies of 44 SLPs have not been received so far. It is however stated by Madam S.P. Bhatti, Additional Solicitor of India, that since the London Micos is forwarding the soft copies to the investigating agency along with his opinion, there is no need of overlapping directions for supply of the soft copies in the remaining cases. That's supposed to after 3 weeks. On
Yes.
so here,
My lord,
There-
my
Manoj, ma'am.
IA for stay.
the above stated directions and directions to observation will be complied with.
My
Manoj and Manoj.
my lord, if I
Just
may
a
be.
minute, just a minute, just a minute. So in written number so and so, it is stated here that despite tendency of these matters, where most of the cases interim notice have been issued, a complaint filed under section 138 NIA Act by the bank,
Yes, by the bank, ICICI Bank.
bank is being pursued against the applicant petitioner. Hmm?
Plus, I'm for the ICICI Bank. I'm
Uh.
not sure which matter my friend is talking about. Plus, if the information be provided, we comply with the stay order. I apologize for interrupting. I'm saying I'm not aware of which matter my learned friend is talking about. If the information.
So, right, may not be aware. Notice has been issued.
My lords, on the last date, we were directed to submit to amicus. We have already done so. Our IAs. Notice has yet, my lords, I have filed 2 IAs, one for implement, one for direction.
Issue notice or returnable so and so. Otherwise, will you accept notice?
Please, Manoj, I'll accept the.
And so and so accept notice on behalf of the so and so respondents. And so meanwhile, questioning the complaint in section 138 NIA shall remain state.
Manoj with my Lordship's permission.
By IA, notice has been issued,
Let's-
kindly stay the criminal proceedings.
Manoj with my.
Manoj, there's one
Manoj,
Initiated by the bank.
19.142. Actually, it's a
Manoj,
transfer
two man.
petition of the petitions which are already pending before Karnataka High Court to this court. Now, the CBI and the amicus both are investigating the same project. Manoj, but parallelly, we requested the Karnataka High Court not to proceed since your lordships are already cognizant of. Manoj, they're still proceeding. So, we have filed an application, Manoj, directing the Karnataka High Court not to proceed since CBI is already investigating. The amicus is also, Manoj, looking after the whole project, Manoj. The petitions have been filed here. Let not the Karnataka High Court do a parallel proceedings may proceed, Manoj. Manoj, then IA
Those
6920.
proceedings are at whose instance?
Manoj, originally the petitioner home buyers were before the Karnataka High Court, but now they are before the court also. They filed a transfer petition seeking transfer of all the petitions.
Who is the petitioner before Karnataka High
Manoj,
Court?
the home buyers only. But now since the CBI here is Manoj already investigating the same project, Manoj on the basis of the transfer petition itself, Manoj, the notices have been issued in the transfer.
Then why you are keeping that matter pending there?
Manoj, the transfer has to be allowed by this court then, Manoj, so that all the matters are transferred to this court. But we informed the Karnataka High Court that the notice has been issued way back in 29th of April 2025. But the Karnataka High Court is still proceeding, saying that if there's no stay, so we will proceed with the arguments. Manoj, there can't be two parallel proceedings that can go on. Manoj, we only request let the Karnataka.
It's only because of your instance.
But now since the amicus is also cognizant of the same project, the home buyers and the CBI is also looking after it, Manoj, investigating the whole project, Manoj. Let not the Karnataka High Court proceed then, Manoj.
I can examine the
We
matter.
do not know where to examine. First to give a copy, let us see.
Manoj, that's been supplied, Manoj. That's 17.
Your Lordship,
Manoj, may I mention, Manoj?
Lordship, if I may, Your Lordship, I filed an application for implement IA number 305205. Your
We
Lordship,
are not permitted you to, you are necessarily start interrupting the input.
I apologize, Your Lordship.
कहाँ से ऑपरेट करते हो ये ऑनलाइन को? किसके पास है यहाँ पे? Mr. Jain, just somebody will seek transfer of the petition.
So
Are these really involving the same point?
I'll do that, sir.
So only then you say in the transfer petitions, let copies of the original writ petitions which are pending before the High Courts, the transfer whereof is sought to this court. Copies and soft copies we supply to the land amicus to enable him to find out prima facie whether the issue involved in those repetitions is similar to the ones pending consideration before this court.
There's just
Malad-
one more request, my lord.
Means,
With respect to the civil, because civil is also a party before this court. My lord, the difficulty what the home buyers today are facing is, my lord, they go to the banks for their medical, my lord, they need loan for education purposes of their children, my lord. The bank is refusing the loans, saying that your civil is absolutely negative.
And we
My lord,
can't.
may consider that these petitions, that the civil.
Next slide.
Malads, the
One
two
request.
emails, Malads, which have been received by the learned amicus, Malads, by the L&T and PNB, Malads, they are filed by me, Malads. The only issue is, Malads, that the petitioner is not my borrower. I have nothing to do with that matter per se.
There may not be, you people enter into very innovative ideas, you people enter into so many agreements.
Correct.
We are not going into.
Malads, there are other matters where
The home buyer is not the direct. I have contract. You have contract with someone else who has funded that to the.
those particular matter, I have nothing to do. L&T is not even, they are not even the borrowers. Neither PNB Housing Finance and those particular matters. Other matters they are. So we have not moved any deletion in
We
those.
not say anything. Let CBI investigate and find out.
Very well.
Consider
Very well.
making this list of 45 cases so that available to the council for the party so that we can better assist. We don't know where our case stands in the CBI list, whether it is being considered, not considered. If
We can't really give you the facilitated individual reports, please.
no,
We are not
the
simply
list-
facilitators here. We are only examining question of law.
Lord, may I make
exactly,
may I make a
that
small
we know where we stand.
Just may I make a small request, my lords? I am appearing in item 17.133. Lordship had made interim order absolute, and Lordship had directed that one unit will be reserved. My lords, we have served him. My lords, he is not complying with the orders passed by this honorable court on 22nd of July, my lord.
No, they have not complied with.
Not complied, my lords, at all.
Who is appearing?
My lords, Oasis Builder is the party respondent number 4 in that SLP. My lords, we have served them with all the means by Dusty and everything, my lords. But they are not, my lords, obeying the
What is
order.
the name of the builder?
Oasis Builder, my lord. Oasis Builder.
What is the name of the person?
Person, my lord. My lord, the name of the person. My lord, sir, what the party in the SLP is through its director. We will find out the name, my lord. I'll find out the name, my lord.
Unless you give the name person, what action we can take?
My lord, I'll find out the name of the director.
Right. What was the order we had passed?
Lordship had passed an order on 29th of April that one unit should be reserved. We served them. Then on 22nd of July, Lordship.
In SLP in repetition number so and so, this court passed an order on
29th of April.
29th April 2025.
Yes, 29th April 2025. Confirmed on 22nd of July 2025.
Confirmed on 22nd July 2025 in terms whereof the builder cum developer is obligated to keep one apartment reserve or what?
One residential unit reserved for me, my lords.
To keep one residential unit reserved for the petitioner. It is pointed out that neither the builder cum developer has filed any reply, nor has entered appearance. Similarly, the above stated orders are awaiting compliance. Who is the managing director, CMD, chief executive officer? They have so many brand names.
Yes, my lord. My lords, I'll give the name of the director, my lord.
Then let available warrants be issued to secure the presence of so and so person in the sum of rupees 10,000. Which place?
My lord's office is at sector A17, sector 2, Noida.
The Commissioner of Police Noida is directed to secure the presence of the above stated person and produce him before this court. In case of any resistance, the available warrants will be deemed to be non-available warrants.
So,
My lords may clarify that in IAs where notice has been issued, the check bouncing proceedings will be stayed.
Madam, we have stayed in your case.
Obliged.
All right, now thank you very much. Give some time for the other matters also. We will see what is to be done. Mr. Jain, let Mr. Jain file the report, then it will follow the direction. And Madam Asurya, with Usman Ligdo, the CBI is also directed to file the next status report on or before the date fixed.
My lords, your lords
Lords,
will hear the
my lords, I
NBCC
seek
the
permission.
Supertech NBCC matters are listed tomorrow, which is what your lordships had tagged on the last occasion. Those will come up tomorrow.
Those are tomorrow.
Those are tomorrow. In fact, my lords, in that
But those were segregated.
those have been segregated. And my lords, in that matter, your lordships have directed me to file a convenience compilation. All of the convenience compilations have been filed. Those can be argued tomorrow.
It will be convenient for us if you give it tomorrow.
Lords, in fact, your lordships have passed that order in May when your lordships were sitting with my Lord Justice Singh. They're all prepared and filed with the registry. But Lord, we can also carry copies if your lordships.
In those matters also, Mr. Jain, you are there to assist us.
No, Lords, he's not there. Lords, in that matter,
That is the-
NCLAT has already appointed a court committee. And Lords, in fact, what had happened, Lords, was this, that pursuant to your lordships,
You will have to tomorrow, not
I'll
today.
argue that. Lord. Exactly.
This is that matter where MBB and this
NBCC has now been directed. Okay.
That is against the main Supertech, the holding companies.
My lords,
I'm in.
kindly be there tomorrow. We will see
Yes,
that what is.
I'll come.
I'm for one of the
Lords, we
interveners, my
would-
lords.
Lords,
In my case, FIR has been registered against the builder, but there's a serious issue of double sale of flats, which has not been considered. All I'm requesting is that the allegations in the IO of double sale of flats, where the single flat has been sold to multiple parties, may also be considered.
Individual cases to be taken up.
Lords, in just one Lords indulgence. Lords, tomorrow, Lords, the lordships may permit me to appear through virtual conference because I may have some difficulty coming physically.
You can appear online and not.
I'll come up. I'm deeply.
It is only when somebody pounds upon us on through online, without realizing that we are dictating order, we are hearing some other arguments, that creates problem.
my lords, the petitioners in item 17.185 and 17.98 seeks permission to withdraw the writ petition and
Very good, very good.
pursuant to settlement agreement. If the lordships may.
How many matters you have withdrawn today?
So just these two.
This third,
No, these two that I am seeking permission before.
allow karo him.
Thank you, my lords.
This is the number. अब she wants to withdraw. कर दो.
That's it. My lord, I have filed 3 IAs in Himanshu Singh matter. Notice has been issued. Kindly stay the criminal proceedings.
Criminal proceeding?
Criminal under 138 against the petition applicants here.
138.
Yes.
Who are you? Home buyers or what?
Home buyer, my lord.
Home buyers. Who has filed 138?
Banks have filed, my lord.
Bank has filed. And you have that subvention tripartite agreement.
Yes, my lord. Tripartite.
All right, stay kar do.
I'll submit. Submit.
Give your IA number, etc.
Yes, all I know.
And please, for God's sake, furnish details of every case to the learned advisors. Otherwise, last time probably we told or we will start dismissing those cases. Wherever now we have granted extended time, all like 2 weeks kar do usme. 1 week user within 2 weeks kar de and give 4 weeks Mr. Jain. 3 weeks thereafter. 3 weeks after 2 weeks. In case the petitioners fail to furnish the requisite information as per the format prescribed in our order dated 20th January 2026, within the extended period, it is made clear that such cases shall be liable to be dismissed for non-procedures.
Lordships, in item 18, respondent number 33 to 35 has not filed counter affidavit. And Lordships, a few of respondents has filed counter affidavit and I seek.
Which item are you arguing, sir?
Lordships,
18.
18 item, Lordships. 18.
18.
Yes, Lordships.
Jitendra Kumar Pandey.
Avanish Kumar.
Now tell us what is the problem.
My lords, the petitioner has misled this honorable court by saying that he did not sign the petition before the High Court. My lords, may kindly have the have page number 21 of my counter affidavit, where he went to the High Court and got his photographic affidavit attested for the purposes of filing the writ petition, in which the impugn order was passed. My lords, may kindly have page number 21. My lords.
There are, look at, we have said our order. Meanwhile, no confidence motion against the elected office bearer shall be kept in abeyance in view of the fact that 12 members who are purported to be signatories to this resolution have submitted affidavit that neither they signed nor supported the no confidence motion.
Yes, my lords.
So let the collector examine this. How can the High Court say that collector can't examine this question?
My lords, as per the scheme of the act, under section 15(2),
We have already explained that scheme of the act.
my lords, the section 15(2) of the act says that collector is not empowered to issue directions to the DP.
Collector is not empowered to ascertain whether they have signed it or not.
Yes, my lords.
In a case where the signatures are there,
Yes, my lord.
then he can't call one by one to verify that these are his signatures.
Yes, my lord.
That is not his prerogative.
This is what has happened.
But if somebody, if I go to the collector, that somebody has produced a no confidence resolution,
Yes, my lords.
which purportedly contain my signatures, and I have not signed it, my signatures have been posed, is he not entitled to verify it? He is.
My lords, out of 35 respondents, 29 respondents have already filed an affidavit before this honorable court that they are in the favor of no confidence motion. My lords, I have filed the additional affidavit before this honorable court that they are in favor of no confidence motion against the block pramukh, Kshetra Panchayat of Sultanpur.
That makes the things more dubious and doubtful, both. They are giving affidavit to him also, they are giving affidavit to you also.
My lords, my colleague direct the district magistrate of the Sultanpur to conduct the no confidence motion within
First we will tell him to verify whether they have signed, and if they have signed it, then he will put up before the no confidence.
My lords, may pass directions to because my lords, the term is expiring in this April only. So in any case, if this matter is prolonged, the SLP will get infructuous, my lord.
Let it be done infructuous. Let them continue. They are elected persons. Well, it's not that they are backdoor entrants.
Once more continuance motion, once more confidence motion. With the lead petition, then affidavit.
जो पैसे दे देता है उसी को एफिडेविट दे देता है.
Yes, that's what is happening.
ये हो रहा है ना?
This is actual what is happening.
What happening?
Yes, yes, my lords.
इनको सबके खिलाफ एफआईआर करा दो इसी एक्ट में.
That's why, my lords, I am praying that a direction may be passed to the district magistrate of the Sultanpur to conduct the floor test.
ये ऑर्डर कर देते हैं कि इसमें कलेक्टर की बजाय we direct the commissioner of police to verify, and wherever it is found that there is some kind of extraneous consideration.
Very well, my lords, very well, very well.
They should register FIRs under PCF and get them arrested and debar them from contesting the next election. That's the only way out.
Yes, lords. Yes, very well, my lords, very well.
And they are blackmailing. Right on. Leave granted. The petitioners have laid challenge to a division bench judgment dated 8th December 2025, passed by judgment dated 8 December 2025, passed by division bench of the Allahabad High Court at Lucknow. Whereby the communication dated 21st August 24 of the district magistrate, which place?
Sultanpur. District Sultanpur, Karodi Kala block.
District magistrate Sultanpur.
Yes, sir.
Yes, my lords.
UP.
Has been declared to be without jurisdiction, and consequently a direction has been issued to proceed with the inverted commas no confidence motion as per the rules and the statutory provision. So the election of This was a block pramukh.
Yes, my lords. Block Pramukh.
The election of block pramukh of
Karaundi Kala,
Karaundi Kala, Sultanpur.
District Sultanpur.
of so and so was held in the year 2021.
Yes, that's it.
Yes.
Was held in the year 2021. In which who is the petitioner declared elected?
That's Vinod Kumar.
In which petitioner number 3 was declared elected. Next paragraph. A notice was issued on 30th July 2024 a notice dated 30th July 24 was submitted before the district magistrate, purportedly signed by 36 out of 48 elected members, for moving no confidence motion against petition number 3. Subsequently, 12 out of 36 signatories to the notice allegedly submitted their affidavits before the district Panchayati Raj officer, stating that neither they have signed nor supported the no confidence motion. One more elected member was disqualified due to incorrect mentioning of his ward number. The district magistrate, having received 12 affidavits, passed an order dated 21st August 2024, holding that statutory requirement under section 15 in bracket 2 of UP Kshatriya Panchayat and Jila Panchayat Abhiniyam 1961 first
Having received 12 academics, passed an order to date 21/8/25, holding that statutory requirements this to that and zero comparison of 19.
Holding that since the statutory requirement in section 15(2) of so and so, namely that the written notice must be signed by at least half of the total elected strength, was not satisfied, hence the initiation of no confidence proceeding. Hence the request for initiation of no confidence motion proceeding was liable to be rejected. Next paragraph. The aforesaid decision of the district Panchayati Raj officer cum district magistrate was challenged before the High Court, and while impugned judgment, the High Court has set aside the same on the ground that a district magistrate has no authority to verify the signatures of members who have signed the no confidence motion as was held by the full bench of that High Court in a previous decision. So the High Court the High Court consequently set aside the order of the district magistrate and directed to proceed with the no confidence motion. Next paragraph. The aggrieved appellants have approached this court. Next paragraph. While examining the scope of powers of the district magistrate under section 15 in bracket 2 of the Act of so and so UPF, this court in civil appeal number so and so titled Ranjit Kumar Maurya versus Ashutosh Patel and others has held as judgment dated May 2, 2025 has held as follows. Para 7. Next paragraph. It may be seen that while the collector is not competent to return a finding as to whether the affidavits appended with no confidence motion were genuine, bore genuine signatures or were forged. However, if the no confidence motion has been withdrawn by some of the signatories and the remaining and the members and the signatory members are far less than half of the total electoral strength, comma, the collector was very much competent to decline to initiate the no confidence proceeding. By you in this case. Right. The contesting respondents have in their counter affidavit relied upon fresh affidavits given by those very 12 candidates who had earlier given affidavit to the petitioners withdrawing their support from no confidence motion. It is apparent that some of the elected members are switching sides purely for extraneous consideration. This kind of dishonest or extraneous practices can cause irreversible damage to the democratic institutions at the grassroots level. It becomes bounden duty of the authority not only to ascertain the genuineness of the affidavits which are frequently exchanged, but also to hold a deeper probe of the extraneous considerations behind such frequent changing minds. Next paragraph. In the instant case, the term of the elected body is expiring in April 2026. Since the no confidence motion is sought to be supported, with such applicants to the with the support of such signatory to the no confidence motion, whose own conduct is highly doubtful, we refrain all those 12 members from casting vote in support or against the no confidence motion. That's the only punishment that should be given at least. Resultantly, the collector, the district magistrate, which place it was? Sultanpur.
Karaundi Kalan, Sultanpur, Uttar Pradesh.
Will take a fresh call as to whether or not the remainder of the members can move any such no confidence motion, and if so, whether such motion should be allowed to be entertained at this belated stage when the term of the elected body is expiring within a very short span. So ideally, this is not the time for a by-election. Is not the time for a by-election for a very short duration. Let therefore the collector so and so place take an appropriate decision after hearing both sides. But ठीक है दो एक before line
decision इसका कराने दीजिए.
Recovery proceedings against the block promote is going on for rupees 5,69,000. He has misused the funds in the Manrega scheme, my lords. So let there be stay on the powers, administrative powers and financial powers of the block promote, my lords. In the meanwhile,
we have sent you back to the collector. You make a complaint there. Collector will examine.
Very well, my lords.
Obliged, sir.
Obliged, sir.
Please. 19 is the contempt
We
proceeding.
were supposed to comply, my lords, and for the alleged contemners 1 and 2, lords, we have made the application and we are awaiting a response for the bifurcation of the khata, my lords, for the purpose of the cancellation of that agreement to sell. Your lordships have the last order, 10th October 25.
Yes.
Yes, lords. Lords, at
10th October.
I beg your pardon?
10th October.
10th October. Yes. Lords, para 4, it was stated on our behalf that it will take 3 months to get the deed of cancellation registered, and we were to file a further compliance affidavit. Now that compliance affidavit has been filed, in which, my lords, if your lordships will have that compliance affidavit, we had applied. In Bangalore, there's been a small development where the Bangalore, the BBMP has been replaced by the Greater Bangalore Authority. So the bifurcation of the khata which is required for this extent of land on which the agreement had been registered has now got to be cancelled. So we have made that application. The BBMP earlier in December told us that they did not have a provision, after which we have reapplied on 10th January 2026. And at para 11 of our additional affidavit, we have received the undated draft khata, and that has to be finalized. So we are asking only for a further 3 weeks to complete this compliance, my lords. We believe that in this 3 weeks, the authorities will be able to comply and that we'll have that reversed. We believe, my lords, there isn't really a contempt, but we are going to fully comply, cancel everything. We'll come back and then make a clean breast of what our position is. Because that survey number covers different pieces of land. So what was the subject matter of your lordship's order is not that land on which the execution was done, but in any event, we're cancelling that.
Agreement was entered into, my lord, in respect of survey number 108/1, which is a suit property. my lord.
Correct, that's correct, that's correct. 108/1 is a large piece of land with different extents within it.
Yes.
But in any event, we're cancelling that one, so your lordship can take it from me, we're cancelling that fully.
So the cancellation deed has not been.
It will take a few more weeks to process, it's not in our hands, my lord. So I've asked for 3 weeks.
So let us see.
I'm hoping that it will be done by
My lord,
then.
I beg to appear, my lord, for respondents 3 and 4. I believe it must be through an error I have been brought in. The reason being that your lordships had passed a status quo with regard to the suit schedule property. My lord, although my property was part of the original plaint, subsequently, my lords, there was an amendment application filed by which it was dropped, and that was allowed as early as 2015. And it's not part of the suit at all. And in fact, even in the SLP, I've taken out an IA to be dropped as a party because I am not in whatever is the suit schedule property, I have no interest at all in. And so far as the property I am interested in, that, my lords, even the amended plaint is on record, which will show that my property has been dropped from the schedule. And
that is an issue, Mr. Sundar. The point is that today we are only on the question of violation of an interim stay.
Absolutely. But I've been made R3 and R4 in the contempt. That's why, my lords.
That we will, once the Mr. Gopal Shankaran says that.
Part of respondent number 3 and 4 also.
Gopal Shankaran and senior counsel representing respondent number
1 and 2. Let's continuous 1 and 2.
1 and 2 state that it will take another 2-3 weeks in getting the
Deed of cancellation registered.
Deed of cancellation registered.
Well, so far as respondent number 3 and 4 is concerned, they are relying upon the amendment, my lord. Amendment has taken place with the consent of both the parties, to which I am not party, my lord. And therefore, my lord, so far as the amendment is concerned, my lord, it will not wipe off the schedule of the original suit, my lord.
We will see what is, let us see the proper cancellation, what's revised. Post the matter after 3 weeks also.
I've undertaken to file a compliance affidavit the minute I get it.
On doing the needful, a compliance affidavit will be filed. First, on behalf of respondent number 1.
After 2 weeks, sir.
Lordships.
3 weeks.
Your lordship will be giving some specific date, my lord, of 3 weeks. Grateful.
Item 20 was. Please, my lords.
34.
Only 5 dates are important in this matter.
Millets, before the petitioners begin, may I submit millets? They have come to this honorable court on singular ground, saying that one identical issue has been pending with your lordships. So
That's a different
the
issue.
Honorable High Court should not decide the issue. Their own pleadings is that's the only issue they have raised. And that was decided last week, saying that one UGC regulations prevail over the state legislature or the university statutes. And that's the issue they wanted to raise here, agitate here. Their pleadings I'll take your lordships, subject to your lordship's pleasure with regard to whatever the hearing.
No, that is not
It is the issue they have raised that has become now concluded.
That is not the issue.
May I just pass on the judgment?
Petition my learned friend is arguing. I am arguing the different petition. Let me place. Well, it's on 5 dates only, just note for this. This is a case without allowing me counter, directing a full stay, allowing the writ petition by holding that the state's enactments are nullified and regulation 7.3 of the UGC applies. If the order of the High Court does this, now note this, Willis. On 12/5/25, during court vacations, suddenly, Willis, a supposed PIL is filed. I'll just give 5 dates for us. 12 May 25, a PIL is filed in Madras High Court, challenging the validity of amendments pertaining to the appointment of vice chancellors. Amendments have been made in the exercise of power by the state government, quasi-state enactments under the list 3 entry, concurrent list. This is filed suddenly in vacation on 12/5. Notice is issued on 14th of May, including a notice on stay. No urgency is shown. Matter is for 21st.
Stay seeking appointment of the vice chancellor.
Stay of the entire regulations and rules and statutes by which the state appoints.
Seeking stay of the amended provision.
Yes, amended.
All.
Correct. Notice is issued for 21st on 15th May. A transfer petition is filed in the Supreme Court saying similar identical matters of some kind are pending here. Forget that verse. The state's transfer is mentioned on 19th May. In the High Court ballots on 21st May, 5 days later, having issued notice, the impugned order is passed without allowing me time to file counter. And the entire writ is allowed. Now turn to my written submission. I'll highlight 3 or 4 things for us. Give the written submission note. Give it quickly. Just come to 2 or 3 things. Give it quickly. Don't play with it. So my first point is my para 2.1. I'll be only selective.
First point, Mr. Naidu,
yes.
Tell us on factually. Is it correct that after 5 days the matter repetition is allowed without any notice?
May I submit minutes?
Without a counter.
Yes or no?
Minutes. It is I who argued before the Honorable Madras High Court. I have got personal knowledge. My lords may kindly see page number. It's been recorded by the Honorable Bench there saying that one, look, we put you on notice, we gave you time to file a reply. You have not come up with any reply. Today you are again asking for more time. All right, put things on hold.
Detailed reasoned order.
Yeah, my lords may kindly see minutes. Put things on hold so that we'll consider your plea. May I just read that 1 minute?
No, can I just place my...
Where are the ROPs before this, before the final order 21st May?
I beg your pardon?
Do we have the ROPs before 21st May?
Yes.
The orders passed by the High Court.
Volume 2 it is.
Volume 2.
Orders passed.
At 652.
652.
This is I'm grateful. I didn't
First
understand.
hearing was 14.
652 minutes.
Yeah, this is the first
This is
hearing.
a very important question which is followed. Let's kindly see this. This is not the way to first grant a stay. Let me suffer and then say now we'll decide it later. Come to 652. Admit. Issue rule NISI. Call for records in 8 weeks. Does my lord have it? Does my lord have it?
My lords, it's only an interim order. The matter is still pending. It is not a final disposal.
What is being argued is in the interim stage, a statutory rule has been suspended.
Yes.
Whether that sort of a compelling prima facie case A was made out, 2, opportunity was given to the respondents to rebut the case that you seek to make in the writ petition.
Yes, minutes.
Well, the balance of convenience is not first stay and then argue. It is first argue and then stay. That is the balance of convenience.
Major your concern, Dr. Singhvi, that these are statutory rules having a presumption of constitutionality.
Now turn to the query by law asked.
Honorable High Court has said twice over the Honorable Supreme Court has decided the issue and it's been squarely covered. Anyway, you wanted to fight. My lords may kindly see it's been said.
We are not on that point. The order may be legally correct.
We will be able to satisfy our
Yes.
Chief Monarch.
No, what they have said. Yes.
Next, this one. This is order 15.5. This is.
No, we are not going to examine this issue, Mr. Mehta. First, the High Court should examine.
That's why, my lords, the time has been given.
The case was moved in a vacation.
The learned Advocate General was requested, please give us an undertaking. You will put things on hold.
My learned friend is.
Whatever the time you want to take, you take.
Lord, my learned
They
friend is
said
not
no.
correct. I was
Not
there in
give
the
you
court.
that assurance.
Lord, matter was moved in the vacation court. The portfolio doesn't say that, my lord, these matters, my lord, will be placed before the vacation judge. Portfolio clearly says any emergent matter that can be moved before the vacation bench. Therefore, my lord, the portfolio doesn't permit, my lord, this matter to be placed before the vacation bench. But, my lord, the person comes from Tirunelveli. My lord, he waits, my lord, after this notification was issued 1 month, my lord, before it was issued.
2 months old.
Yes, he comes in the vacation court, bypasses Madurai High Court. He files, my lord, this writ petitions here and moves, my lord, urgency slip, my lord. Matter was taken on 14.5. Learned judge, we requested, saying that we had filed a transfer petition to the Supreme Court. Learned judge posted the next week, my lord. And despite our arguments, my lord, repeatedly saying that we have not filed a counter affidavit, please hear us. My lord, the learned judge, my lord, switched off the mic and passed an interim order and made certain remarks against me also. But something unheard of, my lord, the way it was conducted.
My lord, this is completely unfair and unethical.
Can I say something else? Your lordship has operating rules.
Attributing motives to the court. if they don't have a point.
Very unfair, my lord.
Which acts?
Lord,
The amendment acts are quite old. Please.
Lord, he has no role at all.
We are not examining on merit, we are examining the manner in which the order is.
Yes, exactly, my lords.
What disturbing us?
That's why.
Lord, Mr. Mehta has no role at all. It's a state legislation being challenged. Lord, he is appearing for UGC. Why is he, my lord, supporting it?
My lords, kindly come to page 5,
exists from
para
before.
4.
Why
Kindly
does
have a look at para 4. What's been said about the whole process? Para 4, my lords.
For the petitioner, can I
Para
place my case
4
for the petitioner?
of the impugned judgment,
This system
page
is
5.
marvelous. Allow me to place my case for the petitioner.
The writ petition. When it comes to the procedure, it has to be set right only to the extent merits they can as well argue.
Exactly,
Minutes.
sir. Let me place my
The writ
case.
petition was listed for hearing on 14/5/25 and was admitted. Even when the matter was taken up for admission.
Why in a vacation bench?
Yes, Mr.
This was not filed during vacation. This was already a pending matter.
Millets, I have complained that they are going to complete the whole process.
You have vast experience. Please tell us.
Yes,
vacation court setting, question of constitutionality of some university statute. What is the daring hurry?
May I give the answer for that? Kindly come to page 7 minutes. Kindly come to page 7. Just have a look at page 7. Just have a look at it. Page 7, para 7.
Yes.
My lords, may kindly see para 7. The learned Advocate General does not dispute the factual position that government orders have been issued constituting such committees and that the such committees have issued notifications inviting application. Last 3 lines, my lords.
Yes.
We wanted to know whether the process could be put on hold till the state petition is disposed of. The learned Advocate General was unwilling to give any such undertaking.
Assuming some illegal appointments are made, it does not prevent the High Court to set aside them. If the High Court finds that yes, there is something the state has in tearing hurry, made some illegal appointments, the High Court can always set aside.
For that purpose, they have said, please give us an undertaking so that we can consider. My lords, it's not that day on the same day it has been disposed of. Earlier it came, the learned Advocate General entered his appearance and court told him that by next time we will consider this one. Meanwhile, you come back with your defense. The next time they came and they said we wanted more time. The court said that one, all right, we'll give you more time. So that it could be considered. Meanwhile, put things on hold. They refused.
These laws came on 11th of April. In May, suddenly in vacation, without any urgency, it is moved. A date is given 5 days later, no counter is filed. The procedure followed is first stay, then arguments. The actual procedure should be first arguments, then stay. Exactly that has happened in 5 days, 14th to 21st.
At length it had been argued. At length it had been argued. More than the whole half a day was taken for all parties concerned. And my lords could see, para 4, what's been said. We put them on notice and informed them that the petition for interim relief would be taken up on 21/5/2025. Well in advance informed. And they came the next time on this day.
All right, Mr. Nadu.
I wanted more time. Now, my lords, even otherwise, the whole thing has become infructuous.
You argue all these issues before the High Court. We are sending it back. We will set aside this order. I don't leave granted. Hard learned senior counsel, Subsidiary Dr. Abhishek Manu Singh and Wilson learned senior counsel on behalf of the state of Tamil Nadu and their authority. Sri Naidu learned senior counsel on behalf of the.
Yes, minutes.
On behalf of Respondent 4.
State of Tamil Nadu. He is a writ petitioner.
He is a writ petitioner.
No, he is not petitioner.
Who actually turns out to be an office
on
bearer.
behalf of Respondent 4.
And gives Madurai Court.
We had Sri Tushar Mehta learned solicitor on behalf of University Grant Commission and Sri Naidu learned senior counsel on behalf of Respondent 4. That's it. Having regard to all the attending circumstances, say the instant appeal is directed against an judgment dated 21st May 2025, passed by a division bench of the Madras High Court. whereby the court stayed the operation of the 10 bills to the extent that they take away the power of appointment of vice chancellors of the universities from the chancellor and vest the same in the state government. That's for the. Since the main case is pending before the High Court and the impugned judgment, though purportedly an interlocutory order, but for all intents and purposes has the effect and impact of the final judgment, comma, it is not necessary for us to express any opinion on merits of the case. All that we wish to observe is that the appellant state and the authorities ought to have been given a reasonable time before passing the impugned order cum judgment. First of all, on this ground alone, comma, the instant appeal is allowed. The impugned judgment and order cum order dated 21st May 25 is set aside, and the matter is remitted to the High Court at Madras. We request the Honorable Chief Justice to list WMP number 20576 stroke 2020 to list WP number 18374 stroke 2025 and WMP number 20576 of 2025 before the bench presided over by him, semicolon, grant reasonable time to the state and the authorities to file their counter affidavit, and thereafter hear the parties on inherent relief from if so required, or preferably the main writ petition itself may be decided. But what you will gain in the main writ petition, Mr. Wilson, after the 5 judge opinion of this court,
so far as this issue, Lord, is not
let's
considered.
leave it to the High Court.
May I add only two things?
Entirely different.
May I add two things, minutes? There was a stay, or still up to now, but they completely disregarded. Even on 24/1/2026, 27/1/2026, they went ahead by conducting interviews.
Lord,
They
impugned
have
order.
never adhered to. They have never adhered to.
Lord,
any
impugned
of
order.
the stay.
Itself permitted.
First thing,
Impugned order allows.
let them not. Let them not.
No, Lord.
Yes.
3 years.
After
3 years, we are not able to fill
we
up.
were
Lord, 20,
contemplating a
16 universities, they are chasing us. Filing litigations for
the contempt case.
Lord, I can't keep my university headless.
See, Millers, when stay has been there,
Lord, that cannot be done.
Please listen us.
It's an illegal
and
order.
they ignore Millers saying that cannot be done.
Please allow to have
Shame, Lord, to keep my universities vacant, my Lord. They are filing litigations one after another. They have been set up by persons.
Please remind yourself, it is not assembly, it is court number 1, Supreme Court.
And for him that applies, not for you.
Your Lordship sets aside the illegal order, then it is heard again. It is no further stay to be given as he is asking.
Dr. Singh,
Yes.
this order was passed in May 25.
Yes.
Almost 1 year it has been operating. We are only pointing out that we need not to mention, but don't, that we are reminding the case on your argument. Don't make an appointment till then.
Now and then, no. Between now and the
Millers, just your lordships have heard.
May I say this, my Lord?
We cannot keep.
May I say this? Any appointment, my Lord, will be subject to the
we have
result
gone
of
ahead. They admit that we have gone ahead.
Can I say, sir?
Just a minute, please.
A legal answer.
Notwithstanding the stay.
Mr. Court,
1 month is not going, you see, look,
page 27,
Dr. Singhvi,
order says,
Dr. Singhvi,
with the search committee.
Dr. Singhvi,
Order says.
Dr. Singhvi, please now consider. We are not going into that.
It will be another form of stay, my Lord.
These are only bill. These are only bill.
No, my Lord. Act has come into force.
No, Act.
Act has come into force, my Lord. It was notified.
themselves
It
have
was
pleaded
notified.
identical
Otherwise,
question.
he cannot challenge.
Yes, my Lord's query is taken care of by the impugned order against me. It says
Well, let's,
there are
in
30
all fairness,
we
since my
committed
lords
ourselves
have said,
to stay in that part of the legislature which takes the power of the governor to make the appointment. In fact, we do not even propose to stay the Constitutional Search Committee. If interim stay is granted, that position will, it says so itself.
but that doesn't say that. Read the complete one.
Para 30 says so. Between just
may I
they
just-
should not do it. You're not doing anything between now and the hearing. Say that. Shall I say it? Shall I say it? Between now and
But
the hearing.
still-
Between the now and the hearing, we don't intend to appoint Wallace. Wallace, may I take care of the Wallace, may I take care of the Honorable Chief Justice's concern? Between now and the hearing of this case, which is proximate, there is no intention to appoint anybody.
Kindly record it.
It will be recorded.
No, man, I am saying so. Why
That's all we wanted.
Then we don't want to embarrass you by quoting and
I don't mind being embarrassed.
His colleague says we'll go ahead.
No, we have an objection in embarrassing you.
I have no problem being embarrassed.
Dr. Singhvi and Mr. P. Wilson, Legislative General Counsel state that from today till the matter is decided, till the interim stay issue or the final or the main case is decided by
Further.
the division bench headed by Honorable Chief Justice of the High Court, no appointment shall be made.
May
No appointment shall be
He is a
made.
resident person to give instructions. Wallace.
Why we are saying no appointment shall be made?
My lord, will religiously follow your lordship.
That's right. In light of the fair stand taken on behalf of the appellants,
My lord, till the application is decided, my lord, not the main case, my lord. Because that
but-
WMP
Application.
till the we were saying something better. We were saying something better.
Yes, my lord.
In light of the fair stand taken on behalf of the appellants, we request the Honorable Chief Justice of the High Court to take up the main case and make an endeavor to decide the same on merits as early as possible and preferably within 6 weeks.
We are very obliged.
I just add one last thing, Millets, for my lord's kind consideration? May I just have one thing, Millets?
When justice,
Very fair order.
Justice Srivastava's retirement is there
Oh.
on 8th March.
That's what I was about to tell
Lordship
Millets.
has said it to be
My
posted
only
before the
prayer is
appropriate
that-
bench.
Let him,
Post before the
Any
appropriate
jurisdictional bench, Millets, any jurisdictional
Post
bench
it
that's
before the
presently
appropriate
there.
bench as per the learned Chief Justice's Wallace roster.
Any jurisdictional bench, Millets. Any jurisdictional
That's a
bench.
fair point.
Otherwise, it casts
He
aspersions
can't do
on
it,
the
he
previous
can't do it
bench
on
for
8
no
March.
reason.
There's no way he can do it. You have lots of other.
Reputation is the only asset of a judge.
the matter may be taken up either by Honorable Chief Justice or he may, if so deemed appropriate, may entrust it to some other appropriate bench. Then say we request the High Court. Don't say Chief Justice. Then we request the High Court that in keeping in view the fair stand taken on behalf of the appellants, we request the High Court to make an endeavor to decide the main case within 6 weeks.
I'm deeply
Grateful,
very
deep
deeply
applause.
All the remarks, my lord.
Millets, as
against
parting one
the
minute.
eschewed. All the remarks.
against the council.
It is clarified that we have not expressed any opinion on merits.
Millets.
For appeal is allowed, the impugned judgment is set aside.
Remarks are expungable.
In view of the fact that the impugned order has been set aside, any observations, remarks, or directions contained therein are deemed to have been annulled.
Deeply.
Are deemed to have been
Very
annulled.
deeply.
Millets. While parting, Millets, we have also been fair Millets on our stand. My lords have said the appellants have been fair. We are also fair Millets.
Don't ask for
We have already
correct
said this is the
fairness,
position.
Don't ask for correct
It has
fairness.
always been fair.
I'm the appellant.
Lord, only one request, not on the merits. If your lordships can consider adding one line, this would not reflect anything on the bench which passed the order.
Exactly.
Because your lordships have said to be,
They've done their job, Millets.
Since we have,
they have not
since
heard it at length.
since we have set aside the impugned order primarily on account of a technical reason, on account of on a technical ground, our order shall have no bearing on the merits of the main case.
Obliged. Very deeply obliged.
On the adjudication of the bench, previous bench. On the adjudication of the previous bench.
It will have no reflection on the previous bench.
In fact,
That's all.
he's bringing the bench into it unnecessarily.
No, no,
That
Mr.
you have brought it.
Mr. Wilson made almost allegations.
Better, better we don't say nothing more.
Yeah, better not.
Please, sir.
Great.
Lord, item 25.
Millard,
If
the transfer petition has become infructuous.
yes,
But simply there was provision transfer petition.
We withdraw that.
Or we say, in view of the order passed in the main case, the transfer petition has become infructuous.
Great.
Whatever way you want.
Yes, yes, we withdraw it.
well, since your lordships are rising, item 25 is the DDA matter where we want to construct a road to approach the hospital, my lords. The state has filed an affidavit, my lord. Can it be on Friday or Monday, my lord, your lordships?
Monday.
Monday.
Millard, item 28, Millard.
The Tamil Nadu DGP
Item 33,
matter, your
Madam.
lordships, the Tamil Nadu DGP matter, your lordships, because the interim DGP.
Today we are occupied with Tamil Nadu or West Bengal.
The lordships have been occupied by the whole map of the country, your lordships. I'm just seeking
It's
next.
not Tamil Nadu.
The Prakashing matter.
Yes.
Prakashing matter.
The very next matter, and this is, we want to take up this matter.
Yes, your lordships.
Next Tuesday.
Next.
Millard, item 28, Millard.
No, sorry, next Wednesday.
Very well. That is
Next Wednesday.
Item 28.
Just a minute. Just a minute. One incentive giving to all of you that all left out matter will be taken on next Wednesday.
On item 33 on Thursday, only item 33 on Thursday.
Parties, both sides want a longer day.
No, but except on when?
Mr. Raju, sorry that we couldn't take up this Prakashing matter. We have gone through your note, and thank you very much for very outstanding assistance you have provided so far. On the next Wednesday, is it all right?
I appear for Tamil Nadu.
Remind all that day as a Micus, you please remind to take up that matter. We will take out of turn. Provided you, just you mentioned.
I appear on the other side.
That's it. So both of you can remind, we will take up on that.
All the Punjab,
Yes.
Only, item 33 instead of Wednesday can be on Thursday. Nothing to connect it with the item.
33, what do you want?
Instead of Wednesday, we can be in Thursday, next Thursday. Or a day
I
after.
don't want on Wednesday.
Wednesday, I have some personal
All
difficulty.
right, next Wednesday.
Very well, next Wednesday.
Fellows, item 26, my lords, if it could be on Monday or Friday, my lords, item 26. It's an LOC quashing matter, my lords. Item 26, my lords, could it be on Monday or next Friday, my lords?
Why next Monday or Friday? You want?
Fellows, I'm in some personal difficulty, my lords.
Is it already shown as NMD?
My lords, no, my lords. It just happened to come up on a Tuesday, my lords, on the first date.
Samnik, those matters which are NMD, which are not NMD, take out those matters and list them on some Monday, Friday.
So grateful.
My lords, in item 20.
Circulation on Monday and Friday.
Your lordship in.
Item 20 is a writ petition, Millard. The Andhra Pradesh writ petition.
That is the.
Millard, even though it is appearing to be a miscellaneous item, it's a
Final
writ
hearing.
petition for.
All right, then from, instead of coming Monday, we will list next Monday.
No, it was a final hearing. So
Final hearing.
Keep it on Tuesday or.
Should be on Wednesday.
Yes, Wednesday.
Then maybe then next Wednesday.
Yes.
My lords, in item 23 matter.
Millard, in item
Next
23,
Wednesday.
Millard.
Today there was some slightly some lengthy matter. So maybe next Wednesday turn will come.
Millard, in item 23.
In item 23, my lords, there was one application for appointing high power election committee which has been appointed in respect of
Yes,
state
my
of
lords.
Rajasthan. My lords, the only request is, my lords, the summer courts will start from 13th of April. So all I am requesting.
Sorry, you are arguing, but my mind is somewhere else. Mr. Naidu, in that order, we can mention that Mr. Naidu write down एक line. Bargain करते हैं ना एक line लिखो. Mr. Naidu, learned senior counsel, fairly states that so long as the impugned order is set aside on technical ground, he has no objection if the matter is remanded to the High Court for press conference.
he has a point.
He wanted to bring the point for you. You also.
Grateful.
At 4 o'clock, my lord, at 4 o'clock, all three of your lordships' face has smile on the. That's the rare thing, my lord. We are really grateful, my lord.
We can work till, I mean, I don't have.
That's amazing.
But
That's amazing.
7, 8 o'clock, we can very comfortably work.
Milord, item number 23, Milord, the Bar Council of West Bengal has filed an application
Bar
for
council, कितने bar council हो गए इस country में?
Lordship may have it, Milord, on any.
Bar council matters, we have decided what you left there.
Milord, we are only seeking some modification so far as the counting of vote is concerned, Milord, because the state assembly elections are clashing, Milord.
Counting of votes. No, counting of votes issue we are not touching deliberately as of now. There is a request. There are 2-3 other requests by some councils for regarding the mode and manner of counting of votes. We are consciously not touching that issue so far. Let the elections be held. Once the election will be near to over, then you file the application.
Your Lordship,
then we lay down.
Your Lordship, in that
You will have to give direction because of the.
Milords, in connected item.
This fact that some directions are required to be issued, how, like for example, how to ensure this 30% representation to the women candidate. Suppose how
proportional representation.
Proportional.
The statute provides for proportional representation.
Facing Milord is that because
how first preference will enlighten us that how it is to be done.
No, in fact, we are working out the modalities, my lord. We'll place
So
before
you
my lord.
prepare a note, and you can also, all of you can also prepare on this side.
Yes.
Give us a note. You will tell your note must ensure that the women candidates get not less than 30%.
I understand.
Your benchmark will be not less than 30%.
I understood.
My lord, in item 23 itself, my lord, in relation to Madhya Pradesh Bar Council, was some erroneous fact came in the order because of which the Bar Council of Madhya Pradesh has delegated this to Bar Council of India. Bar Council of India is saying that the fact is recorded in the order sheet which is not correct because this term has already expired. In the order sheet it has come that term is going to expire in July. So they are doing nothing. They are just shifting from here to there.
No, but we have already directed the election schedule.
No, but they are saying that there is a letter, my lord, that they have
Lord,
saying that.
so I understand. So my friend was just telling me, for Madhya Pradesh, the term was till October.
Yes.
That statutory extension of 6 months.
Extension can't be.
No, my lords, no. Therefore,
I'm not
that no. My friend will bear me out for a minute.
On the oral mentioning, the issue of election of Bar Council of Madhya Pradesh is taken on board.
Lord,
The IA is.
can I make one request? They wanted to know the.
Called by Shri Guru Krishna Kumar Land, Senior Counsel representing Bar Council of India, on instructions that the original term of
The committee
of the State Bar Council.
State Bar Council got over in October, and it is on the extension of 6 months, and they are taking steps to conduct the election.
However, an extension of 6 months was granted.
Under Section 8. Under Section 8.
Was granted under Section 8 of
the Advocates Act. Yes.
So that the elections could be held meanwhile.
Correct.
Yes.
It is accordingly directed that the elections of the Bar Council of Madhya Pradesh shall also be conducted by 30th April 2026. The high-powered election committee headed by Justice Ravi Shankar Jha, former Chief Justice of Punjab and Haryana.
Because I had one request to make.
Monitor.
On the last part, I had a submission.
Of the Bar Council of State of Madhya Pradesh.
I had just one submission.
So far,
But the extension took place as the statutory extension under 8.
So
they will be taking steps, my lord. I'm only saying whatever is the regime which has been brought in, because those are all instances where the committees were already expired.
Term expired in October. 6 months will expire in 30th April.
Therefore, my lords, they will now be taking steps in the usual course in a timely manner. I'm only saying.
Nothing.
Election no, can I do one thing? No, can I do one thing?
You must take emergency steps.
No, they will. Can I make this request? Can I make only this request? On the conduct of election, my lords, please have it on Friday. I will take some instructions.
All right. We will grant time till even 30th June. But then we will today dissolve the Bar Council and we will appoint an administrator. Choice is yours.
Yes, because they are
very simple choice.
No, I'm only saying, 1 second, madam. I'm saying,
so
I'm only saying that my
exercise the option. Which one is accepted?
I'm only saying this. I'm instructed.
Whom we are proposing to appoint?
No.
No. We can tell you.
It's not on that at all, my lords. It's not on that at all. They are now going to do it. There is no need for a committee, is all they are saying. That's all they are saying, my lords. That's all they are requesting. It's a statutorily expired.
Very simple. You want an administrator or you want election? You don't worry. Madam, whatever wrongdoings or wrong things are happening, please send them to, just a minute, write a detailed representation to Justice Sudhanshu Dhulia, former judge of this court, who is the chairman of the high-powered election monitoring committee for all India. So you please bring to. Oh, I send it.
The IA is disposed of.
Lordship may take up the IAs on next Wednesday.
For Rajasthan, my lords.
Rajasthan.
39.
Rajasthan, we have already passed order.
Only request is, my lords, only request is the courts are going to be morning from 13th of April onwards. So election may be conducted prior to 13th.
It's all right. That committee will take care of it.
That Madhya Pradesh IA is disposed of, my lord.
IAs are into, and item 23 is of which state?
My lord.
Item 23, my lord,
And my.
And 23 and 39 are
Yes, my
then
lord.
nothing survive in 23 and
No, nothing survives, my lord.
23 and 39 says appropriate direction for conducting the election of Bar Council of State of Rajasthan have already been issued.
Yes, my lord.
And a election committee has also been constituted.
Yes.
Nothing survived in these petitions for adjudication.
Because just one thing, my lords, when 23.
They relating to Madhya
Just,
Pradesh
so far
also
as-
disposed of.
just one aspect.
my lord, so far as West Bengal is concerned, we are only seeking a limit.
Processing matter next Wednesday.
Plus 23, the IAs come,
This side mein sune aap.
I'm so sorry. 23, my lords, what my lord just pointed out, the main matter is M. Vardhan, which is there. Therefore, that's not disposed of. Some IA came. Otherwise, 23 main writ is there.
My lord, the number I have given.
IA pertaining to Rajasthan election.
Yes.
That's correct.
Also
That's so.
Madhya Pradesh, my lord, which your lordship has taken on board, my lord.
So now in Madhya Pradesh, election by 30th April.
Yes.
You will happily agree if I will disclose the name of the proposed administrator. So better you agree.
My lord,
Madhya Pradesh by 30th April.
my lords, in item